I'm sure as you all do too. So we're on section 13. No, I'm sorry, we're on section 14. We're getting ready to close out the semester. And we've got a couple of very important things in this week's abbreviated class at this point. But it's constructive trust, resulting trust. We looked at declaratory judgments a couple times already. So we're going to really focus on the constructive trust and resulting trusts in this case. And both of them are used. They are court-imposed trusts as a result of violations of the law where it would be inequitable or unfair to allow the person who is presently in possession of that property to retain that property. And so what the court imposes as an equitable measure is either a constructive trust or a resulting trust on that property for the true owner. And it depends on whether it's a constructive trust or a resulting trust, depends on how that person acquired the property wrongfully and such that it should really belong in the hands of another. So the first case we have in this to deal with constructive trusts is Sanguinetti versus Nantucket Construction. And it's an interesting case to me because what you've got is an individual who was a lawyer who had an awful lot of dealings on this piece of real estate, and down on the vineyard, was it the vineyard or Martha's Vineyard or Nantucket? Well, down, I'm sorry. I think it's Nantucket, down in Nantucket. And so what happened is there was a piece of real estate and that this Roy Sanguinetti, who was the lawyer in this relatively small town, was wearing way too many hats as he represented various people with respect to this property. And so they were cranberry bogs and the like. And so we had Roundsville told Sanguinetti, who was the lawyer, of the offer to the property and his desire to purchase it because of its value. Sanguinetti advised him that the property should be purchased. They made arrangements, and Sanguinetti, in essence, represented just about everyone involved. He drew up a handwritten memorandum of agreement. The parties initialed that as well. And then he told them how to deal with it from a business standpoint as well. Sanguinetti then, he arranged for a bank loan to purchase for the purchase money. Sanguinetti was a trustee and a conveyancer for general counsel of the Nantucket Institute for Savings. Said there'd be no problem in obtaining a mortgage. I mean, he just had his hand everywhere there was in this transaction. And the problem for him is now he's dead. So he can't tell us his story. It's going to be left to whatever documents we have and information we have as to what really, what we think happened. But what we do know is that he's not going to be testifying. A deed to the property was prepared again by Sanguinetti, sent to the Shepherds for signing, signed by Mrs. Shepherd as trustee. She returned it to him. There was did not note the name of the grantee in the deed, but both he and his wife at all times considered Roundsville to be the buyer because that's who they dealt with, and they thought he was the attorney. And what happened is that the mortgage and the promissory note were prepared again by him. The note stated the maker was Sanguinetti under a declaration of trust. And the mortgage given to the bank named him as the trustee for Lee Holmes and the like. He registered the deed and the mortgage, and that deed and the mortgage was then recorded using his name, Roy E. Sanguinetti, trustee under the Declaration of Trust, and giving him full powers to deal with the property. There's all sorts of shenanigans going on at this registry because he actually has a key to it. This was years ago, but and so he could actually go into the registry when it would otherwise be closed. You know, there's a lot of lawyers in small towns where they have sort of the run of the place. I'm not sure they get the run of the registry anymore, but if you think about some of these smaller towns where the lawyer, whoever is that lawyer in town who's hardwired, he knows all the boards and he comes and goes, or she comes and goes, and they have a great deal of power and influence. The problem is they've got to be careful though, because when they overstep their bounds, that it's pretty easy to find that they've abused their fiduciary duty. And as we can see in this one, he's dealing on juggling so many different hats all at the same time. It's hard not to say that he was shirking his professional responsibilities and his fiduciary relationship to the clients. You know, he's acting as attorney, it says here, 290, acted as attorney for all of the parties. And so sometime during the period from 63 to 65, Sanguinetti asked Brownsville to sign another instrument which would then put the property in various names, including Sanguinetti. Brownsville refuses. They said, well, let's divide the property so that we can use it to each of our advantage. We don't need to do this anymore. At the end of the day, he had a fight with them and he said, no, you know what, forget it, this is my property now, none of you have any ownership of it. And the question becomes, is it Sanguinetti's, or is it these other folks who are in fact, who were supposed to be the owners of the property, who were supposed to take advantage of it, of the purchases and the like? What they want to know is, can we impose a constructive trust or a resulting trust on this property that should have been ours from the very outset, but because of the shenanigans that have now taken place here, we've in essence been cheated out of our property, and it's unfair to allow it to happen. Look on page 292. It says a constructive trust, and that's what they're looking for here. Constructive trust is imposed in order to avoid unjust enrichment, right? Unjust enrichment of one party at the expense of another, where the legal title to the property is obtained, A, by fraud. So there's got to be fraud involved, or B, in violation of a fiduciary relationship. Does the attorney stand in a fiduciary relationship with their client? Yes, right? Or C, where information confidentially given or acquired is used to the advantage of the recipient at the expense of the one who disclosed the information. Did Sanguinetti take this information that was obtained by him confidentially and use it to disadvantage his clients under the circumstances? And there's almost no doubt when you look at what happened here and look at the circumstances, that did Sanguinetti obtain property by fraud in violation of the fiduciary relationship? Almost, you got the first two and the third one. Information confidentially given or acquired is used to the advantage of the recipient at the expense of the one who disclosed the information. This is a classic example of a constructive trust where the court is going to impose it. Sanguinetti was in a position of trust. As attorneys, we are in a position of trust with our clients, and to the extent that we then use information they give us to their disadvantage, we would be unjustly enriched if we were allowed to keep it, and therefore we can't under the circumstances, be allowed to profit by it. The court is going to impose a constructive trust on the property, and that's, I think, the only appropriate relief here. There's one thing that I want to bring to your attention that is worrisome about the case, but I think in part it's because he's the lawyer, because he stands in such a superior fiduciary relationship to these folks, that we're not going to listen to this argument on laches. Laches, we've said before, is an equitable defense. It is delay which causes prejudice to the other side. To me, there is some laches here, right? Brownsville's now dead. The only person who could probably, if he testified truthfully, tell us exactly what took place between all the parties and at all the times is Brownsville. Is Sanguinetti. However, Sanguinetti is dead. They waited till after he died to bring suit. That sure is a delay which causes prejudice to the other side. Well, how do they know that there was something wrong? Because when this went down on the Boggs at one point, he said, well, you've lost the property, it's mine now. At that point, I think you're very easily able to make the argument that a reasonable person in the circumstances at that point would say, I better go find out what the hell is going on with my property. And not having done so, I think there's a fair argument for laches. The problem is, if we allowed laches to take hold there, then we're going to potentially advantage the corrupt lawyer who took advantage of his own client and the confidential information he received, and that would be bad public policy to allow that to take place as well. So even though I think it's a good example of laches, I think they don't say it per se, but I think in part it's because of his position as a lawyer that they don't give as much credence to it as one would normally. Because, a classic case of laches is where key witnesses have died due to that lapse of time that you unreasonably delayed bringing suit. If it was someone else, I think you might have a slightly different result, because I think it's not a bad case for laches. The problem is that I don't think they're going to allow any benefit to attach to him, because they think what he did was on a number of occasions fraudulent and the like, and he shouldn't be allowed to benefit by it. Sullivan versus Rooney. This is a Massachusetts case, and it's an interesting case. It asks you, again, about the imposition of either a constructive trust or a resulting trust. But there's some, and again, what we're trying to do by the imposition of either a constructive trust or a resulting trust is avoid unjust enrichment by the person who has the property at the expense of another. And so in order to avoid unjust enrichment, we're going to impose either a constructive trust or a resulting trust. And so let's see what the difference is, and let's see how that would work. First of all, I got a couple of legal questions here, because the case brings up some some legal terms that you should be aware of. It says the judge's rulings of law speak of compensation for services in a quantum meruit theory. What's that? What's quantum meruit?
Being able to sue off the contract.
Say what?
Being able to sue off the contract.
So what are you suing off the contract for? What though?
Damages.
Say what?
Damages.
Damages for what?
For what that you've done.
So work that you've done.
You're not completed, but you've done to
So so what are your damages? What are they for quantum meruit? Say what? Part performance? Well, that's what you may have done or may not have done. What do I get for quantum meruit? What are no Latin scholars here? Quantum meruit is an equitable suit for the reasonable value for the services or the goods that you provided. It's off contract. We're arguing now even if there's not a contract, I'm entitled to quantum merit. I'm entitled to the reasonable value of my services or goods that were provided, right? So we have to then, and that's what she wants to do. At least that's what some of the judges' rulings look like, that they want to compensate her for her services on a basis of quantum merit. What's the reasonable value of the services she provided? And then it says here, the plaintiff argues that the defendant's oral promises to give her one half the property are enforceable in the circumstances despite the defendant's reliance on the Statute of Frauds. What's the Statute of Frauds? Go ahead.
A writing that needs to be required for specific types of documents.
Like what?
My legs. It's marriages, contracts over a year, land.
All land?
executory-
All land?
Okay.
Is
All
it?
land that is.
So land contracts all have to be in writing?
Correct.
Okay. What about $500? Isn't there something about $500 in there somewhere?
Yeah.
$500
Goods
or
over
more.
What?
$500
Goods?
or more.
Any contract for $500 or more has to be in writing?
Yep.
Okay. So any contract for $500 or more has to be in writing. Contracts involving real estate, marriage?
Yep.
What do you mean? What
Contract.
does that mean? Because I never signed any contract when I got married.
Consideration of marriage.
Huh?
Consideration of marriage.
What do you mean?
It could be a.
Is that, no, what do you mean by that? I am married, but I had signed no contract. So what do you mean, like a
PNS is a-
prenup
is a
or something?
A PNS is a product and sale agreement, is a marriage contract.
But but where did you learn this, in contracts? Okay, so I'll talk to one of the contracts, because I'm not sure I don't understand what you mean by,
The example was, if you marry my daughter, I'll give you the moon.
oh,
Like anything that has to do with marriage. That was the end.
Anything that you promise in proposal of that marriage. So if you promise the moon, then you're entitled to give the moon.
but only if it's in writing, he's saying, I thought.
Correct. That's the marriage contract.
Okay, I'm gonna have to track this down, because I'm just not sure I understand, right? Do most of us have, how many of you are married?
Yeah.
Did you guys sign a contract when you got married?
No.
That's what I mean, I'm just not sure. But I could see prenups, things like that, I get that. But so I'm just not sure what that means, contracts of marriage.
I think it's what it said, it's in consideration of the marriage, so if.
If you make if there's a contract in consideration of marriage, it's gotta be in writing.
Yeah.
Okay,
For
yeah,
instance, if you have a dowry or something, if
Yeah.
you followed some kind of dowry system where you promise to give a certain amount of gold to.
it's gotta be in writing.
It's gotta be in writing.
Well, I understood it.
It kind of still confusing.
I understood it slightly different, because when you think about what a marriage is, it requires what? A ceremony, a certificate, and it has to be in front of somebody. So when we talk about the statute of frauds and we apply the marriage component of it, I think what they're referring to is that the marriage has to be legitimate, so that means it has to fit all those requirements for it to be a recognized marriage. Therefore, that certification from that marriage becomes a legitimate.
Well, I do think
contract.
we signed something too, right?
I'm not married, I don't know.
Well, we're gonna track it down, but anyway, let's get back to Sullivan versus Rooney, because I'm sorry, it was my fault that we started late, but, so the question is, listen, they were, living together while he went to school. And while they were living in his home. Hold on, let me be clear on that. They lived together in a house in Reading that he purchased, because he was working at the time and he was a veteran. On the way to the registry of deeds for passing the papers, defendant told the plaintiff, this is I think her testimony, that in order to get the 100% veterans at VA financing, he would have to take title in his name alone, the deeds recorded. So they're living together, they're sharing expenses, sort of. She's paying the household expenses, food and clothing and things like that. He's paying the mortgage, the rent and everything else. And they lived together in that house from 78 to 80. When the defendant who a career Army officer, had been admitted to the bar of the Commonwealth, transferred to D.C., he worked full-time during the day as a ROTC instructor, attended law school at night. He paid the mortgage, obligation, taxes, utility insurance, and the property. Plaintiff, a waitress, put all her earnings and savings into the house, paying for the food, household supplies, and much of the furniture. They split up. She says, I want my half of the house. He says, what half of the house? Your name's not on the title. Statute of Frauds says if you've got some deal about the real estate, it should be in writing. There is no writing, right? And she says, but I still want half the house because that's what was promised to me. That's what she says. So, the only way she can get it, because we do not provide for palimony type suits, the reasonable value of the services that your boyfriend or girlfriend provides to you. If she's going to get half this house, she has got to see if the court will impose either a constructive trust or a resulting trust upon the property. What she argues is that his promises give her one half of the property and they are enforceable, or, despite what the statute of frauds may say, or that there's a constructive trust here. In order to have a constructive trust, we just saw it, there has to be a fiduciary relationship between the parties and that the defendant violated his fiduciary duty to her. Equitable principles impose a constructive trust on property to avoid the unjust enrichment of a party who violates his fiduciary duty and acquires the property at the expense of the person to whom he owed that duty. Are you in a fiduciary relationship with your boyfriend or girlfriend?
It depends.
What do you mean it depends?
Depends on how much money you're splitting up together.
So if it's a little bit of money, you'll be in a fiduciary relationship, and if it's not, you won't? I mean, fiduciary relationship means, in essence, a position of trust, right? So you in a position of trust with your boyfriends or girlfriends?
Should be.
Oh, should be or are? Because in order for her to get to the next step, you got to say, no, we're in a fiduciary relationship. Are you in a fiduciary relationship? Here they were living together. Are you in a fiduciary relationship with your living partner?
Yes.
You are.
If you're living together, yes.
So if you're living together, you're in a fiduciary relationship with your partner.
Well, I would agree with that, just on the simple basis that, you know, if you're living together, that means that your household expenses are joint together. So there is some type of fiduciary duty there. Now, if we're just boyfriend and girlfriend, you live over there and I live over here, I don't know about that.
Well, so what about that? So we don't live together exclusively. We're together 3 or 4 times a week in one or the other house. So you could live with someone and not be in a fiduciary relationship with them, not be in a position of trust. You would invite someone into your home to stay, but not be in a position of trust. I mean, not stay. I mean, stay. Not
kind of trust,
not on a one-time occasion. I'm saying, you know.
That kind of trust, I don't think is the same kind of trust that fiduciary relationship requires.
So I don't have the ability to trust
I mean, that kind of trust,
that partner.
I trust that partner, but that kind of trust does not extend further, like the kind of trust.
I think what my colleagues referring to is like that's more so a moral trust.
Exactly. The word moral comes into it. I mean,
as opposed to a legal duty as to,
I don't
you know, I
really
live
agree.
over there, you live over here. I don't see how there's some type of fiduciary trust between us two, because technically speaking.
So we're not in a position of trust with those who are extraordinarily close to us, is what you're saying.
Yeah.
Oh, you're not really saying, well, that's a different trust than one that's going to impose a legal obligation as you see it.
To answer your question, I would say no.
No. Yeah.
Hard no.
Okay. Marissa, you're being quiet. Do you feel the same way? No. Well, and isn't, okay, so part of it is we've got to get the position of trust in order to get to the next level, right? Okay, so is it reasonable? I say, is it here the plaintiff was less educated, less experienced than the defendant? She relied on him over a long period of time in important matters. Don't we rely on our partners
Yeah, we do. In this case, I would say there's trust in this, but when we're talking about like a hypothetical where there's two different, dwellings, and the people are living in those two different dwellings, things a little bit different because.
So we gotta be together in that house, and
I think that's a fair. I
It's
think
a greater amount.
I think that's
there's
fair.
more trust when
Right.
the safety net has been cut.
Right.
Okay, fair, okay, I can sort of accept that. Is it reasonable for her then, in this case, to rely on him?
Yes.
It is reasonable.
Okay, so if so, then despite what the statute of frauds says, we can impose a constructive trust and give her half of this house because they were in a fiduciary relationship and he violated that fiduciary relationship, and it would be unjust to allow him now to take the entirety of the property despite what the statute of frauds says.
No.
No what?
No, she can't take like majority of the property, but that's where that quantum merit theory would come into place to protect her interests. Now.
Wait, hold on, before when you say that, read the last sentence here.
Which one?
His latter promises to transfer title to joint ownership, and the plaintiff's reasonable reliances on those promises made by one in whom she reasonably placed special confidence call for the imposition of a constructive trust in the plaintiff's favor on one half the Reading property. She was in a fiduciary relationship. She had a right to rely on that. He used that information to her advantage, to his advantage. She gets half the property.
It would have been more convincing to me if they were like kind of married or something.
So for those of you that are living with someone and not married, so they could have half your car?
No way.
Well, what do you mean, no way? Because that, right, I mean, this is sort of a shortcut around palimony, right? We can't do quantum merit, and that's why they can't do it, because we don't provide for the reasonable value of services for live-in lovers. Just not what Massachusetts does. If we're going to do it all, it's got to be constructive trust. And here it is. And there's a lot of issues this opens up, Sullivan versus Rooney, because what it allows then is sort of a side door to circumvent the statute of frauds. On the next case, Forden versus Roman Catholic Bishop of Worcester, I want you to look at it because it gives us a couple of really good definitions of both resulting trust and constructive trust on 789. And it also raises the issue that I want to touch on briefly about churches and the like. You know, we have this whole other system of justice that we know virtually nothing about. And for churches that have a certain structure, much of their practices cannot be examined in civil courts. They can only be examined in church courts. And so we're going to talk a little bit about that next time, because there's actually a fair amount of things that are left to the resolution and not available for civil courts to examine. Even in the church of the sexual abuse cases, one of the arguments that the church was using was the entirety of this negligence claim, this negligent supervision claims about the priests abusing parishioners. A lot of that, as they see, dealt with two church practices that are fundamental to the church. One of which is forgiveness for our sins, right? You say you did something wrong, you say you won't do it again, and we forgive. And the second one is, church practices, is the assignment of priests. And what the church argued in part is that those are fundamental practices pertaining to our religion. And no civil court has any ability to examine that under the First Amendment. And so if you have a problem with what happened, then you need to take it under canon law to a church court, and we'll let you know how that works out for you. And honestly, they filed a brief with respect to it, and it ultimately, the Supreme Court had to examine it. We had to oppose it. But they were arguing that at least part of their practices dealt with church matters and church matters can't be examined by civil courts. So the issue does come up, and we've seen it, and we'll see it a little bit in this next case as well, but it is something we have to start to become familiar with. I remember early on in my practice, I had a teacher come in to talk to me. She and her husband were Orthodox Jews, and what she wanted to pursue is she wanted to pursue a divorce, but she also wanted a religious divorce, and under the practices there, she could not pursue it unless he consented, and she had to get what they call get a get in order to move forward with a divorce in under the courts pertaining to her religion. And so these matters come up occasionally, but it is something to be familiar with and start to give it a little more thought to, because we don't usually touch much on it in law school. I will see you and talk to you next time.